Hey, what's up, guys? Welcome to Law Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, small law firm in central Minnesota. And today we're talking about, again, the Georgia lawsuit in the 2020 election, the Kraken unleashed by Sidney Powell, as it were. This case was filed on November 25th and has been moving throughout the Thanksgiving holiday and the weekend in pretty quick manner. And we're going to take a look at this order for a temporary injunction, temporary restraining order, basically, in this case. And let's take a look at it, and then I'll share some thoughts about it. But as a very preliminary thought, because I don't want this to get missed, just because a case moves very quickly or because there appears to be positive movement in a case doesn't necessarily mean that it's great or bad or anything else. There's nothing to be read into the urgency that is applied to this case other than the fact that we are in very urgent circumstances. So they have really until December 14th till the electors cast their vote for any sort of court intervention to take place. It has to really be done by then. So we're on very, very accelerated timetables, and anything about this is subject to change at any time. In fact, this order was issued at 10:10 p.m. on Sunday, the 29th. So to give you an idea of where courts are with this and how seriously they're taking it, there are no such things as weekends or anything in this game at this point. Things have to happen when they happen. So that's just something to bear in mind. Try not to read anything into the timeliness based on, on a particular side doing something better than another. That's not an accurate reading. It's the nature of the timeline and the importance of an election that it's framed under, that it has to be crunched down. Okay. And final thought, it's ultimately on that timeline, and this being so late in it, where there is a significant risk to this lawsuit, where they simply say you should have done all this sooner, as we saw in Pennsylvania and as we're seeing in other states. This should have happened sooner. You waited too long, etc., etc. So that's the caveats. Let's read what kind of happened at the hearing. It's there's a summary in the order here about what the main two arguments were. We'll go through that and I'll share some thoughts. So during the hearing, the defendants, that's Governor Brian Kemp and Secretary Raffensperger, the defendants' counsel argued that the Secretary of State has no lawful authority over the election officials of the counties, citing Jacobson versus Florida Secretary of State. Sidney Powell, or the plaintiff's counsel, responded that the plaintiffs could amend their complaint to add the elections officials in Cobb, Gwinnett, and Cherokee counties, obviating the issue of whether the proper officials had been named as defendants to this case. Look, they don't want this thing tossed out on some technicality like we saw up in Pennsylvania, right? Where the counties that actually denied two of the plaintiffs' votes were not included as defendants, and the judge made a big deal out of that. Now, those counties weren't the target. The target were other counties, and that was part of the issue there, is they were trying to use those two people as an example on the other counties, but the judge said, why aren't their counties included? Boom, out. So they don't want this. They've proposed, yeah, we can serve them if that's what's necessary in the case. So then the defendants' counsel argued that allowing forensic inspections would pose substantial security and proprietary trade secret risks to the defendants. So let's break this down real quick. Dominion Software likely has proprietary and trade secret interests in their software that is on the election systems. However, these systems, Dominion is voluntarily contracting with the United States government, right? Or with county governments to participate as the guarantor of election results in a free and fair election in these counties where they're working. And they're getting hundreds of millions of dollars to do this. And now they're saying, well, but you can't inspect our stuff because that might risk our trade secrets. No. I'm sorry. When you're voluntarily entering into an election, to decide the leader of the nation, your proprietary and trade secrets are put sort of in a jar. And the government might have to dip into that jar. They just might. No one asked you or forced you to create software. The government didn't enlist Dominion Software to make this sort of product and say, you have to do this or we'll nationalize you or shut you down or something. Dominion freely entered into this. They have represented to the government that their machines are safe, that they do what they're supposed to do, that they are accurate, and now they're being challenged on it. You have to allow inspection. That's my opinion. That's my opinion. But this is something I've mentioned a couple times with these sort of things. Part of the challenge is you may have some proprietary or trade secret information that is part of this that could complicate things. Again, my opinion, you missed that boat when you contracted with the government to participate in their election. Now, we the people whose taxpayer dollars paid for this software, we have the right to look at it. And your trade secrets, I'm sorry, they're on the chopping block. In my opinion, very humble opinion. Okay, so the plaintiffs, however, argued that the defendant's concerns could be alleviated by an order from the court allowing the defendant's own experts to participate in the requested inspections, which would be video recorded, and directing the experts to provide whatever information they obtain to the court and no one else for an in-camera inspection. That's an inspection by the judge away from the public view. Everything would be under seal, and the judge would then make the determination of whether or not this information was proprietary, whether or not it puts trade secrets of the company at risk. All of those things would be made, and then the judge would be able to release whatever information necessary to the public in the interest of transparency and open courts. And then if there were things that could not be released to the public and could not be released to the individual parties, it could, however, potentially be released to specific attorneys to act either within the team's counsels, right? So existing attorneys or amicus attorneys could be appointed that are have separate interests, I should say, than the main counsel, and they could consult on the issues while maintaining confidentiality and segregation of the data, if necessary. That would be up to the court to determine that stuff. Again, we're on a crunch timeline, so we'll have to see. So those are the arguments. What the judge has done now is ordered that the defendants have until Wednesday, December 2nd at 5 p.m. Eastern to file a brief setting forth in detail the factual bases they have, if any, against allowing 3 forensic inspections. The brief should be accompanied and supported by affidavit or other evidence if appropriate. So they have not ordered the inspection yet. They have not ordered the inspection yet. They have merely ordered that, you'll see that the machines need to be preserved, and then they will have a ruling, presumably on December 2nd, over whether or not they will be able to inspect these machines. So they have to have a hearing on December 2nd about the machines, and then the judge will have a ruling on that as quickly as possible. And then further, the defendants are enjoined and restrained from altering, destroying, or erasing, or allowing the alteration, destruction, or erasure of any software or data on any Dominion voting machine in Cobb, Gwinnett, and Cherokee County. So they're not allowed to do any updates. They're not allowed to do any deletion of data or any manipulation of the data at all until the judge is able to take a look at this, until their hearing on December 2nd, and then a further order of the court. Otherwise, this restraining order does expire in 10 days. And so we'll have to see if there's no order by then. In theory, they could alter it in any way they want, although that would probably be a bad choice. All right, so that's what's happened here. It is a very interesting development. It does not mean an inspection will issue. It merely means that we now have a date for when the arguments are due, and we will presumably get a ruling very quickly after that date, because again, they will have to rule, the inspection will have to occur, the data will have to be returned to the judge, So that's one whole aspect of this. The other aspect of this is that this order itself could be actually appealed, or any order that is made by December 2nd could be appealed very quickly and expedited up to even the Supreme Court of the United States if necessary, due to the time constrictions of this, due to the possible existence of federal questions, and due to the nature of a national election hanging in the balance here. So we'll see. We'll see what happens. All of this is subject to change at any moment. This is, again, a fast-moving case, but it is an interesting thing that it has not been immediately tossed out of court. So there's always the next step to watch for, and we'll be watching for it here. So if you found this informative, if you want to try and keep up with this election stuff, I know I'm scrambling to, go ahead, hit like, hit subscribe, share, do all of that stuff. And then make sure you hit that little bell on the subscription button. Also, I do a nightly live stream at 11 p.m. every weeknight, and we talk about these and other issues on those live streams as well. So come check that out if you want. Otherwise, we'll keep watching. Hope you have a good day. Peace. Peace.